A three-judge bench of the Supreme Court is hearing the mercy petition filed by 1993 Blast death row convict Yaqub Memon. The investigating officer of the case has also reached the Supreme Court. This after a two-judge bench was split on his plea seeking a stay on his execution. Now the new bench will decide whether to stay the death warrant issued by the Tada court. It will also decide whether Yaqub's curative petition will be heard afresh. With the hearing underway in the Supreme Court, the 1993 blast victims have also filed a fresh plea with the governor. Now, Justice Anil Dave and Justice Kurian offered sharply different views on Yaqub's mercy plea. Justice Dave had dismissed his plea, but Justice Kurian differed and favoured a stay, saying that Yaqub's petition must be heard afresh. Earlier, Yaqub Memon had challenged the death warrant, saying that it was issued before he could exhaust all legal options. Joining us in the studio now, Kapil Sankla, Supreme Court advocate, and Vinay Tiwari, Managing Editor, India Today. Kapil, KTS Tulsi there is pointing out the procedural lapses. Now, that matter is going to be decided today. What is the precedence to that?
You see, way back in 2002, the Honorable Supreme Court had crystallized the law on curative petition. The judgment, I believe, was called Hora versus Hora. Now, this judgment is very interesting because this judgment stated that even after the review is dismissed, the Honorable Court can take up the curative petition under the inherent powers, and secondly, under the inherent powers can call any person or see any document that has not been seen before. Now, thirdly, what it stated was that the three senior-most judges of the Honorable Supreme Court, as well as the judges who heard the main petition, should form a bench to hear the petition, firstly in chamber, and after which it could decide whether it could be heard in the court itself. So this is the law as has been crystallized by the Honorable Court way back in 2002, and that should be followed today also.
All right. And what is the other aspect, Vinay, that the court could look into today, the three-judge bench?
No, to add to Kapil's point, that particular judgment that he's referring to, 2002 judgment, also laid out two other very important things. They said that a curative petition can be admitted only on two grounds.
Okay.
Ground one is when a principle of natural justice has been denied to the person, or the convict can somehow convey or convince the court that there was an element of bias in the judge. One of the arguments that has been put forward by Raju Ramachandran in this case is that the fact that the court has accepted his curative petition means that the principle of natural justice has been denied to him. Because there is no obvious bias.
Yes.
And that is something he has repeatedly said in the court. That the fact that you're hearing my curative petition means that you admit somewhere that my natural justice system has been denied to me. Which is why, what is the hurry in doing this? And let's hear this out in full. And I think that's what is now playing out in the court today in the large bench.
And is the hurry on part of the administration also something, which has been part of public discourse really, and people have questioned why the Maharashtra government was showing this undue haste in preparing for the hanging on the 30th of July, which was the date issued by the Tada court. But does that also make the case for the defense stronger?
You see, let us not mix the issues here. The issue of preparation for the hanging is an administrative function. Now, what would happen, for example, if the curative petition, the subsequent curative petition would have failed, or if this application that was moved or the larger bench would not have been constituted? The administrative function was that the administration had to prepare under the law and order situation and other aspects for the hanging. That is a separate issue. So that cannot be mixed today. Undue haste on the other aspects, yes, because the death warrant were signed without even taking the government into the loop, and they were signed before the entire process of defense was exhausted. So there the defense is correct in saying that in terms of the judgment of the Shabnam and Salim judgment, the death warrants were signed before the entire process could have been exhausted. That is correct. But as far as preparation for the act that is supposed to be committed tomorrow is a totally different issue at hand.
Also, Vinay, Yaqub Memon has put in a fresh mercy plea with the president now in his own handwriting. Will that really matter at this stage?
No, I don't think it matters at all, and I think Kapil will perhaps shed more light on that, but I don't think that matters at all, because his mercy plea has been rejected already by the President and the Governor once in the past.
But his lawyers must have done some work on it, you know, to make him personally write that.
My suspicion is that it is a little bit of a, you know, there's also a time-buying tactic that's sometimes very often employed by defense counsels. I think the defense counsels have noticed that there is a split view within the Supreme Court itself. Yesterday, Justice Joseph and Justice Dave were completely in disagreement with each other, and I think they've seen a bit of a hope there, and they've done this now, perhaps before the three-judge bench started hearing it, just as a matter of additional time-buying tactic. I think that's perhaps what the intended reason is. Whether this will work, you know, at all with the court or not, I doubt.
All right, let's get in a word from Amrita Shedge, who is standing by outside the Nagpur Central Jail. Amrita, you had told us just a short while back that Yaqub Memon has in fact written that mercy plea himself in his own handwriting and handed it over to the Nagpur jail authorities. Has that been sent across to the President? Any word on that?
See, we have got this information in the morning from the sources of prison department that Yaqub Memon has written the mercy petition in his own handwriting and has handed over it to the prison department, and now prison department has already sent that mercy petition to the President. This is the last chance, last mercy petition given by Yaqub Memon, but definitely all eyes are on the Supreme Court's decision, because that will be the final decision. If we talk about the ground reality here, as I said, from last 2 or 3 days there is huge security force deployment here, because that is prison department's work, because on the death warrant, the scheduled date of Yaqub Memon's hanging is written, and that is 30th of July at 7 AM. So definitely it is the work of prison department to make all the arrangements according to that. So prison department is now going forward with considering that date, but definitely the decision, after the decisions of Supreme Court, the picture will be clear. Back to you.
Okay. Now, while the Supreme Court hears the 1993 blast convicts plea in New Delhi, elected representatives of the BJP and Shiv Sena are staging a protest outside the Maharashtra Assembly. The protesters raised placards outside the Assembly against Yaqub Memon. Slogans were also raised against those who spoke out in support of the 1993 convicts, such as Salman Khan. The protesters demanded the execution of Yaqub Memon.
Voices against Yaqub Memon growing. We are outside the Maharashtra Assembly, where Shiv Sena and BJP MLAs have gathered in large numbers and are shouting slogan against those who are supporting Yaqub Memon or have been moving petitions to support Yaqub Memon. There is, they are also protesting against Salman Khan, calling it a support to somebody who is against the nation. Voices of dissent are growing against those who are supporting. We would like to know from you, sir, क्यों ये आंदोलन हो रहा है?
जिस आमदारों ने इसको सपोर्ट किया है याकूब मेमन को, उसको भी निलंबित करो, ऐसी हमारी मांग है। इस आमदारों को बर्ताव करो, ऐसे गलत काम कर रहे, क्योंकि याकूब मेमन ये देशद्रोही है, कोई वो समाज प्रेमी नहीं है।
सलमान खान के पे क्या नाराजगी? सलमान खान के खिलाफ भी आंदोलन कर रहे हैं आप?
सलमान खान ने भी उसके तरफ जो बर्ताव किया उसके बारे में, इसीलिए सलमान खान को भी देशद्रोह का गुन्हा दाखिल होना चाहिए।
प्रोटेस्ट आर ऑल्सो अगेंस्ट सलमान खान। सलमान खान के खिलाफ क्या नाराजगी आपकी? सलमान खान के खिलाफ प्रोटेस्ट क्यों?
खान का जो बजरंगी भाईजान है, वो फिल्म पाकिस्तान में कुछ चल नहीं रही है, वो फिल्म पाकिस्तान में चलनी चाहिए, इसलिए उन्होंने एक ट्वीट किया कि याकूब मेमन को फांसी रोक दी जाए।
आपका क्या कहना है? यहाँ पर आप आंदोलन कर रहे हैं, मुंबई बम धमाकों के आरोपियों के आरोपी होनी चाहिए, या सिर्फ एक राजनीतिक शो है?
इसमें राजनीति कोई नहीं। जो भी कुछ बाउंसपेट में मरे वो किसी धर्म के नहीं थे, सभी धर्म के थे, और ऐसे लोगों को अगर कोई सपोर्ट करना चाहेगा तो वो देशद्रोह का गुनाह उस पर सलमान खान हो, और कोई ऐसे ऊपर देशद्रोह का गुनाह होना चाहिए। हमारे देश में रहेंगे, हमारे देश में खाएंगे, और देश विरोधी कार्रवाई को अगर ताकत देंगे तो उसके ऊपर देशद्रोह का गुनाह होना चाहिए।
The protest also against the supporters of Yaqub Memon, also against Congress MLAs who have been demanding to commute the hanging into life imprisonment. Large noises here outside Maharashtra Assembly, BJP and Shiv Sena members together protesting against those who are supporting Yaqub Memon. The noises against Yaqub Memon surely growing. With camera person Kiran Saptal, Kamlesh Sutar in Mumbai for India Today.
Mustafa Sheikh is standing by outside Yaqub Memon's family's residence in Mumbai. Mustafa, if you just heard that report of the protest there outside the Maharashtra Assembly of BJP and Shiv Sena MLAs asking for Yaqub to be hanged. Now, with the atmosphere so politically surcharged, what is the family saying at this point?
See, the family at this point doesn't want to be politically incorrect, so they are not demanding on and commenting on Salman Khan's tweet on Yaqub Memon. But as far as the neighborhoods of Mahim are concerned, they are fully in support of Yaqub Memon and family. In fact, we just got to know that there are daily prayers which are taking place in Al Hussein Towers of Mahim building in support of Yaqub Memon, that Yaqub Memon's death sentence should be commuted. So the neighbors of the Mahim residents where Yaqub Memon family stays are solely in support of Yaqub Memon and Salman Khan. The argument for Salman Khan which they are giving is that a person who is a citizen of this country has the right to say whatever he feels about a particular issue, and that issue shouldn't be politicalized. It should be taken as on humanitarian ground as to whatever Salman Khan felt he has tweeted on that issue.
Vinay, you know, there is such a sharp divide here, as Mustafa is pointing out. Now, have we ever seen the atmosphere so politically surcharged, as well as such a sharp division in opinion over this contentious issue of death penalty being, you know, somebody going to the gallows?
Yes, but I think right now the issue is purely related to Yaqub Memon. And what is a little surprising is that, as you know, he was very rightly saying, Kapil was very right when he was saying that most people who are protesting or making a noise have very little knowledge of what is actually happening in the court. What is happening in this case is rather unprecedented in Indian legal history. So are we now saying that something which has in Supreme Court has rarely reviewed or reheard something 4 times over? Yes. There has been a regular order, then there was a review petition, then there has been a curative petition, and currently the bench is actually hearing the process of the curative petition itself. Very rarely will you see so many reviews of one case. The fact that people are taking extreme positions in this case is a little illiterate, in my opinion, and I think that is what is creating a problem. This noise factor that is building up increasingly in our society and amongst the media as well tends to deflect the attention away from the real core matter. The core matter right now is only procedural, which the court is listening. I think the merit and demerit of whether culpability established or not has been now established beyond doubt as per the court of the land. We got to respect the institution of the land and go by what it says. There is no other way of living in a civilized society, and that's the system that people have to learn to accept.
Also, Kapil, what I'd like to understand from you is that, you know, there is also this aspect that his family is raising now that, you know, he is medically unfit. He has been a schizophrenic, has been on medication since 1996 for schizophrenia. Were all those matters raised earlier? Does it really make a difference at this stage to raise those matters? Because that also seemed like a desperate attempt by the family to, you know, throw in issues to, you know, just delay the hanging, or maybe just, you know, for the hanging to never happen.
You see, there's a rule saying desperate times require desperate measures, and that is exactly what is happening in this case. So therefore, the issue whether he in fact is suffering from schizophrenia would, in my opinion, in fact go against him, because he has moved a second clemency application before the president, and which he could not otherwise write in his own writing if he suffers from a mental disease. So therefore, I think a number of independent processes are being utilized to either delay the proceeding or to slow it down or to get some more breather. There is no concerted effort at this time to ensure that the matter which is being argued before the Supreme Court is argued only on the legal aspect of it. These independent things that are being done cannot in any way color what is happening in Supreme Court today.
All right. Let me quickly give some updates from the Supreme Court. This came in at around 12:27. Is that Attorney General Mukul Rohatgi had started arguments on the matter, and just before that, we'd also learned that Yaqub Memon's lawyer Raju Ramachandran had completed his arguments at around 12:09, and then the National Law Universities, that is the intervening petitioner lawyer, was arguing in the court, and at 12:27 is when Mukul Rohatgi started his arguments in the case.